Guilty. San Bernardino County Fire Protection District, under the leadership of Fire Chief Mark Hartley, guilty of the unlawful termination of Division Chief George Corley, his age being the substantial motivating reason. Over the past few months, I've been able to experience firsthand the civil court process of law through a trial filed against the San Bernardino County Fire Department by a former division chief that my dad, as fire chief, dismissed from employment. George Corley, 58, claimed age discrimination as to why he was fired. The Federal Age Discrimination in Employment Act bars employers from discriminating against workers that are age 40 years old or over. Therefore, employers are at risk of litigation by all those terminated over the age of 40. The question now comes down to both the rights of the employee and the employer. Hourly workers represented by bargaining groups have property rights to their jobs and are therefore entitled to progressive discipline and due process. However, salaried, non-represented, at-will employees serve at the pleasure of their appointing authority and may therefore be terminated for a good reason, a bad reason, or no reason at all in the state of California, as stated by an employment expert called by the defense in this case. Typically, to make up for what seems like an unlevel playing field between salaried, at-will employees and non-represented hourly employees is a significantly better pay and benefit package. Employee terminations, however, cannot be based on an unlawful reason, such as discrimination based on age, gender, sexual orientation, disabilities, race, religion, etc. The plaintiff in this case was a salaried at-will employee and therefore served at the pleasure of the appointing authority. My dad started at San Bernardino County in 1992, where he worked as a paramedic, firefighter, captain, and engineer. He soon transferred to the Rancho Cucamonga Fire Department in 2005 as battalion chief and soon promoted to deputy chief. While with the Rancho Cucamonga Fire Department, he immediately noticed a high standard of professionalism and performance with a high degree of accountability to the community. When the fire chief's position opened up at San Bernardino County in May 2011, my dad applied. Upon being hired, he immediately sought to set the same high standards of professionalism, performance, and accountability that he helped establish in the Rancho Fire Department. He challenged his new organization to be better than they were and assured them that he would set an example of the expectations he required of them. He introduced the book Good to Great by Jim Collins and often said that being good wasn't good enough, that they needed to be great. You can imagine how important it is for a new fire chief looking to establish new standards to have a management team that is committed to embracing the same values. While most of the staff embraced the challenge and direction of the new chief, some withdrew and in some cases outwardly challenged him in his direction. George was one of these employees. As my dad came to find out, George actually competed against him for the fire chief's position. Even from the first meetings, while most staff was leaning forward intently and taking notes, George was leaning back with his arms crossed. After observing and interacting with him for a few months and discussing his attitude with his immediate supervisor, the deputy of operations, my dad was faced. It became clear that he wasn't on board with my dad's vision for the future of the county. My dad, after so much thought and analysis, considering George's many years at the department, my dad was faced with a tough decision. Either try to make it work with George or explore options as to how to make it work without him. With his commitment to make the organization better and the realization that George was not willing to do that, my dad started to explore his options as to what his options were in regards to George's employment. He met with legal counsel and human resources and confirmed that George was an at-will employee and therefore could be terminated without cause. George was officially notified of his dismissal, citing incompatibility of management style. Within 6 months, he filed a lawsuit claiming age discrimination, even after he was working as the fire chief of Running Springs, within a month after his termination from the county. Both parties tried to avoid trial by entering into settlement discussions. However, after 3 attempts of mediation between the county and the plaintiff, they were over $1 million apart. Thus, the 5-week trial began. The process of jury selection was interesting as each side tried to seek jurors that would be sympathetic to their case. During the voir dire, potential jurors are questioned by the judge and the attorneys. It has been argued that the voir dire is often ineffective at detecting juror bias. A study on the problem of juror bias conducted by Valerie Hans and Elaine Deal talks about the inevitable biases of all jurors and judges as a result of different attitudes, backgrounds, and life experiences, and how the VAR jurors often ineffective at detecting these biases. As I sat through the trial, it became clear to me that this was not a depiction of real life. I saw both sides try their best to keep out as much evidence as possible to make the jury look favorably upon the case that they presented. I watched the judge show obvious bias despite swearing to be impartial, and I saw the attorneys portray my dad in a light that was in a false light as they tried to make him out to be a liar who cuts corners and has a vision to eliminate all the older workers. I watched the plaintiffs say anything and everything to win over the jury despite whether their accusations were true or not. I learned that what the lawyers say during a trial is not considered evidence, but only what the witnesses say. After telling the jury that, the plaintiffs brought up witness after witness to testify to lies against my dad. All the witnesses that testified were either disgruntled former employees, people who hated my dad, or people who had also been fired. I remember realizing that this was not a reality. Everything the jury was presented with was false facts and false testimonies, and they were persuaded to believe that it was the truth. After the verdict, the jurors are invited to stay and talk to the lawyers. Through these discussions, we learned that the jury had no age-related reasons as to the plaintiff's determination, despite rendering a verdict that his age was the substantial motivating reason. After watching this trial unfold, I have realized how little truth is portrayed. The case presented to the jury wasn't reality, and it certainly wasn't justice. The jury awarded the plaintiff lost wages amounting to $704,000. Even this number was completely inaccurate. While I've always been under the general assumption that the process of law was fair and served justice, I know now that it's not always